Testing, testing, testing. Greetings, greetings, greetings. It is I, King Clifford Jefferson, a Senator of Godfrey, the fifth Cannibal Jew, the son of folk, the ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we call Jesus Christ, or the Vicar of Christ, or Melchizedek, better known as the King of Righteousness. It is December 21st, 2024, which is equivalent to our birth year, 2974. I greet you in the name of the ancestors. I greet you in the name of the elders. Greet you in the name of the past forefathers, foremothers, the children, the fathers, the mothers, as well as all those who are trying to get understanding of what it is that we are here and are called to do. I greet you in the name of our Queen Sister Godwinson from the House of Godwinson. I greet you in the name of my Archbishop Melvin from the House of Belmont, as well as all officers on the staff. I greet you in the name in the name of love, truth, peace, freedom that we all desire in this world today. Greetings to you, uh, Ayade Olade. Greetings to you. Let me pronounce that right. Ayanda Aladea. Greetings to you. If I pronounced it right, if I haven't, please forgive me. Once again, it's a beautiful day to be here again. Have another marvelous lecture prepared for you, all my brothers and sisters, my heirs and successors of the Kingdom of England. As I, your King, come to pave the way for you once again with another marvelous lecture. Once again, like, share, subscribe. All those who have their gift donations, free and common sockets, please send them to the Third Temple English Church of England or $ Clifford Jefferson L. Greetings, Countess uh, Brown from the House of Brown. Glad you were able to join us today. I'm glad you were able to assist me in my moderating. Once again, it's a beautiful day to be alive here in what we call present day North America. We know this is England, but hey, we don't throw the baby out with the bathwater. I'm a little tired today, but nonetheless, I'm gonna try to do my best to do what I always do and prepare the word, give the word so you can receive the word so we can all follow what the word says. This lesson is called Governor and Attorney General, Malfeasance and Nonfeasance of Office, says the Supreme Court of New Jersey. Governor and Attorney General of New Jersey have violated their office by way of malfeasance, misfeasance, non-feasance of office, says the Supreme Court as well as the Appellate Court of New Jersey. We're going to talk about this today. Okay, as always, I always have a narrative. It's going to be coming from the actual Attorney General Matthew J. Plotkin's own voice. Okay, they're taking over what we call the city of what we call Paterson. Paterson is the county in New Jersey, parts of Paterson Township. All right, Paterson Township is under the Faulkner Act or Optional Charter Act. Okay, once again, greetings, Brother McGarrett from the House of McGarrett. Paterson is under what we call an optional charter or the Faulkner Act. Okay, so it's very important to understand the terminology I'm going to use today. They're all legal and sound, as well as we're going to go over some case law relevant to it from the Appellate Court, Supreme Court, as well as we're going to go over some terminology that was used in the court in regards to language that we need to know pursuant to how we're being subject to the jurisdiction there based upon their quasi-judicial and quasi-legislative actions. Okay, so with that, let's get started with this marvelous lecture. I promise not to hold you long. If there's any question, please post them in the chat. Once again, greetings to you. Ayende Alade, greetings to you. Everyone else I'm familiar with, once again, thank you for being here today. It's beautiful a time out in the skies. I'm not going to speak too much about that. Once again, I don't like to speak on things I know not of. We like to keep our eyes in front of us, not in the air and not in the sky. All right, whatever comes out of that, let it be. But once again, we're all trying to get understanding what we are trying to do here on Earth. Okay, so with that, let's get started with this marvelous lecture. You're welcome, Brother McGarrett from the House of McGarrett. Everyone pay attention. You can save all the chat for a little later. Right now, I need you all to pay attention. Everyone needs to pay attention. If you don't hear something that you don't understand, please post it in the chat. Okay? Once again, this lecture is called Governor and Attorney General has been accused of malfeasance and non-feasance of office, says the appellate court and the Supreme Court. I only put the Supreme Court, but the appellate court is going to validate what the Supreme Court has ruled uh, back in 1952. If I'm right with the court date of the year. Greetings, Archbishop Belmont from the House of Belmont. I'm glad you were able to join us today. Once again, it's a beautiful day to be alive. So once again, I want to start you to hold you too long. So let's get on with this marvelous lecture. I'm pretty sure you all going to have a lot to talk about after you watch this lecture because it's paramount to our position here at the Third Temple English Church of England, reformed from the English Church of England in regards to our estate, which is shortly to be returned to the heirs. That's intel because it's reserved for the crown, being that you guys don't exist, so automatically it's the crown that has the seating power, and as the concept of the crown in lieu of escheatment, it only arises when there's interstate, meaning that there are no more heirs. And being the fact, uh, the state of New Jersey has taken it upon themselves under their eminent domain power to steal the estate from us. We call this, in lieu of today's lesson, we call it supersession. Once again, everybody needs to write that word down. Supersession. Supersession. Okay, we're going to define that term as well. All right, he's going to use this term as well. New Jersey Attorney General takes over control of Paterson Police Department. We know a police department is a municipal agency under the control of the municipal government, which is headed by the mayor and his staff. We know the county is overseen by the county prosecutor, and we know the state is overseen by the attorney general. All right, they are all under the control of the executive officer, which we call the governor, and that term is suspect. Okay, that term is suspect today. All right, and I give honor to the ancestors because that clarity just came today. All right, the term governor. We always been using the term loosely, but the understanding of what origin, where it came from, didn't come to me today. This is the reason why this lesson is very, very important for all those who have been following the temple and uh, the um, the language that we are using here at the temple. It will fall right in line. For those who are new, you need to go back and watch the previous lecture because you know I'd always say, he who writes your book sets your timeline. Time never was when man was not. The life of time began when man began, the time when man become no more. Once again, time never was when man was not. If the life of time when man and woman began, the time will come when we will be no more. Okay? So we have to go according to our own story. Okay? So with that, let me stop stalling and get on with this marvelous lecture. These are the words from the Attorney General for the state of New Jersey, Matthew J. Plankin. Watch how nervous he is. Moderators, if you can hear it, please let me know in the chat. If you can't, please let me know in the chat. That way I can solve that issue before we even get started. All right. If you can hear it, just give me a thumbs up.
Something has to change, and it will change, starting now. Earlier this morning, I exercised my authority as Attorney General and superseded the Paterson Police Department. Effective immediately, my office has assumed control of all law enforcement functions of the Paterson Police Department. I have appointed Issa Abbasi, a 25-year veteran of the New York City Police Department and current Chief of Strategic Initiatives for the NYPD, to become the officer in charge of the Paterson Police Department beginning in May. Chief Abbasi currently oversees policy reforms for the entire NYPD police force. He has served in the NYPD since 1997 and has successfully managed command of more than 30,000 members of the force. So something has to change, and it will change, starting now. Earlier this morning, I exercised my authority as Attorney General and superseded the Paterson Police Department. Effective immediately, my office has assumed control of all law enforcement functions of the Paterson Police Department. I have appointed Issa Abbasi, a 25-year veteran of the New York City Police Department and current Chief of Strategic Initiatives for the NYPD, to become the officer in charge of the Paterson Police Department beginning in May. Chief Abbasi currently oversees policy reforms for the entire NYPD police force. He has served in the NYPD since 1997 and has successfully managed command of more than 30,000 members of the force. So something has to change.
Okay.
And it will.
Everybody heard it. The state of New Jersey Attorney General Matthew J. Platkin has superseded the municipality's police department. Okay? Patterson's police department, he has superseded. Okay? This particular matter was brought to the district court, in which ruled in favor of the state and the attorney general and his appointments. But it went to, then shortly after that, it went to the appellate court. The appellate court overturned what the district court ruled on in regards to the quasi-legislative and quasi-judicial practices of the administrative government, known as or under the authority of the governor and the attorney general. But as a result of the procedural process, a stay has been put forward so that they may have their ability to appeal the decisions of the appellate court, which, if you read the appellate court's decision, it was rooted in what the Supreme Court stated back in 1945. Okay, yes, he sounds very nervous. All right, so he's superseding authority that he does not have. Okay, we are going to see that today. Not just him, but he who he appoints. Okay, he and who he appointed all are acting de facto in their nature, which is lieu of what we call supersession or superseding with authority that they claim they have under quasi-legislative and quasi-judicial assume authority, which we're going to see is non-feces and malfeasance and misfeces of office. All right. So it's very important that you brothers and sisters pay attention, because it all has to do what it is that we're doing here at the Third Typical Church of England to actually remove them from office, okay, which is taking place right now in the Chancery Court as a result of their assumed authority or superseding. If you don't have authority to supersede the police department of the Patterson, New Jersey, then you definitely don't have the authority to supersede Crown land, which is under the authority of the Crown. All right, so with that, let's get started with this marvelous lecture. I'm going to play it one more time.
Will change, starting now. Earlier this morning, I exercised my authority as Attorney General and superseded the Paterson Police Department. Effective immediately, my office has assumed control of all law enforcement functions of the Paterson Police Department. I have appointed Issa Abbasi, a 25-year veteran of the New York City Police Department and current Chief of Strategic Initiatives for the NYPD, to become the officer in charge of the Paterson Police Department beginning in May. Chief Abbasi currently oversees policy reforms for the entire NYPD police force. He has served in the NYPD since 1997 and has successfully managed command of more than 30,000 members of the force. So something has to change. And it will.
Okay. So something has to change within the city of Patterson. I agree with him stepping in if the municipality are not acting based upon what they were authorized to do in lieu of the municipality police department. I do not agree with him superseding the police department uh, if they're not acting in the capacity as authorized by the law. Okay, and as we're going to see that both the municipality and the state are acting outside of the authority over the term that they call superseding, which originated from what we call supersession. Okay, so it's very important that you understand what's taking place in your government on the national as well as on the federal level. All right, because we're taking it all. We're going to take it all. All right, so with that, let's get started. Let's look at the statement from the Attorney General. Oh, that's too bad. Matthew J. Placken, Attorney General for the Department of Law and Public Safety. This is an administrative agency that was allowed to incorporate within the state of New Jersey, which is governed under Title 52 of New Jersey Revised Statutes. Okay? It was temporary. It's a provisionary government that got their authority through the incorporation of their government, i.e., through their charter. Okay? Not the Constitution. All right? The state of New Jersey is not operating based upon the Constitution. They're operating based upon their statutory incorporation. We must understand that. Greetings, Countess Walker from the House of Walker. Glad you were able to join us today. All right. We must understand that the state of New Jersey is not acting under the Constitution. Okay. We're going to see that today. They're acting on the legislative rules that were created, whether through joint resolution or bills created under the authority of the executive department, i.e., your governor on the state level or your president on the federal level. All right. Them and their cabinets. Okay. I.e., their council. Statement of the Attorney General, Matthew J. Platkins, on the court's decision regarding the suppression of the Patterson's Police Department. Okay? First of all, let's define suppression. Let's define that first. Because a lot of you probably don't even know what that means. Right? Oxford Academics. There are several ways in which rights may be lost by renunciation or alienation, through wrongdoing or forfeiture, and through prescription, or the expiration of rights, or the expropriation by competing claimants. Once again, there are several ways in which rights may be lost by renunciation or alienation, through wrongdoing or forfeiture, or through prescription, or the expiration of rights, or the expropriation by competing claimants. One form of prescription is called supersession, where rights are alleged to have faded away over time to be replaced by others who claim claims of rights. Okay, so suppression is where rights are alleged to fade away over time to be replaced by other claims of rights. Chapter 7 within this book, called Boundaries of the Authority, is an in-depth examination of the idea of right of suppressions. That idea is centrally employed by inadequately analyzed in virtually all theories of territorial rights. The chapter distinguishes from true suppression various related phenomena. It then examines and criticizes all of the familiar arguments in favor of suppression, i.e., superseding, with special references to Wardren's well-known approach. The argument considers concerns of fading bases, shaky counterfactuals, changing circumstances, and evolving demands of justice. Okay? So when we're dealing with supersession or superseding, it all has to do with the conveyance of land by an unlawful practice. Okay? Whether it's through prescription, whether it's through renunciation, whether it's through alienation. All right, these are all forms of unlawful conveyance of property. In this case, we're talking about the land called New Jersey, as well as the land that you call the United States of America. Okay, but one step at a time. All right, we know that United States of America started with New Jersey. Okay? All right? It started with New Jersey. We're going to prove it. Everybody like what you hear? Please give me a thumbs up in the chat. Statement from the Attorney General. Statement of the Attorney General Matthew J. Placken on the court's decision regarding the suppression of the Patterson Police Department. Okay? Office of the Attorney General. We are deeply disappointed with today's ruling by the appellate court. They didn't say that, but that's who ruled on it, the appellate court. And the day which it was ruled on was December 18th, 2024. Once again, December 18th, 2024, the appellate court ruled that the state of New Jersey, under the authority of the governor being executed by the attorney general, does not have the authority of supersession. Okay, this was declared by the Supreme Court, the appellate court, on December 18th, 2024. December 18th was also the same date that New Jersey incorporated in 1787. December 18th, 1787 was the day New Jersey incorporated as a sovereign state. Okay? We must understand how important these facts are. Okay? We are deeply disappointed with today's ruling, which comes nearly 2 years after the state took over the Patterson Police Department, having now spent millions of dollars to improve conditions in the city. And will be appealing immediately to the New Jersey Supreme Court, which they did. They are automatically granted a stay. Okay? For decades, supersession has allowed both attorney general and county prosecutors to directly manage law enforcement agencies when the circumstances call for it, as they did in Patterson when our office stepped in following a fundamental breakdown of the community's trust. Now they're doing it all in the name of what we call supersession or succeeding, okay, which is all a form of prescription, okay, alienation, acquisition, okay. They're doing it all in the name of what we call, whether you want to call a right of discovery, right of conquest, it's called prescription of sovereignty because New Jersey is claiming to be sovereign, okay? They're claiming to be taking the place of the sovereign. We know the sovereign is a monarch, but in this case, they refer to the sovereign as a governor, okay? We're going to prove it. All right, where was I? For decades, supersession has allowed both the Attorney General and the county prosecutors to directly manage law enforcement agencies when the circumstances call for it, as they did in Patterson when our office stepped in following a fundamental breakdown of the community's trust. Since then, murders, shootings, sexual assault, robberies, and other violent crimes in Patterson have all plummeted. While officers' morale and community trust have dramatically improved, we are enormously proud of the extraordinary progress the Patterson Police Department has made, and we remain deeply committed to Patterson and to the crucial work of making the city safer for all its people, including as this wrongful decision is appealed. Once again, including as this wrongful decision is appealed. The decision does not take effect immediately, and we will be seeking emergency relief from the Supreme Court to protect all the progress we have made to date. Okay? We have made today. This is from the letterhead from the office of the desk of the Attorney General, Matthew J. Placken. Okay? Matthew J. Placken. Let's see. All right. So now let's go to the decision from the Supreme Court. Superior Court of New Jersey Appellate Division. All right. Docket number A 0629-23, approved for publication December 18th, 2024. Okay? Appellate Division. We see it here, December 18th, 2024. Now, that's very important to understand because New Jersey incorporated on December 18th, 1787. And the governor, the attorney general at that time, was William Patterson. State of New Jersey. All right. County before statehood was called United States Province of New Jersey. Admitted into the Union December 18th, 1787. Okay, watch my work. 1787, they became a union. Prior to that, they was under the authority of the Crown of England. Okay, they didn't have the Act of Union until 1707. The Crown was here in 1702. Okay, under the King's Bench, now at this time called New Jersey Provincial Council. We went from the Witten to the Courier Regis to the Parliament of England to what we now have what we call, to the King's Bench to what we call New Jersey's Provincial Council. Okay, when they incorporated the state of New Jersey, they moved it from Perth Amboy to now Trenton, New Jersey, because the county seat, the crown seat was either Burlington or what we call Perth Amboy, which is back now. It's in Perth Amboy. We are situated, or our domicile of our incorporation is in Perth Amboy. Okay, so as we can see here, it was incorporated on December 18th. Once again, December 18th, 1787. Okay? 1787. That's an important date to remember. Present governor now is Phil Murphy. Okay? Right? So New Jersey is the plaintiffs in this matter, or they will be the appellates, and there will be the what they call the appellees. You got the appellee, the respondent, and the appellate court. You got the plaintiff and the defendant, and a civil, criminal, or whatever case that's brought before court, and they're in what we call original general jurisdiction. All right, so it would be plaintiff, defendant, and the court of review would be appellate, respondent, and in the higher court of review, which be the Supreme Court, it would be uh what they call the petitioner. Okay, depends upon what you're going to. It would be the same, but if you're filing the writ, it would be a petitioner. All right. So it's very important that New Jersey was incorporated in December 18, 1787. At the same time, okay, the state of New Jersey was found in violation, acting outside of their official capacity, and the case ruled on by the appellate court December 18th, 2024. Okay, let's go back to the case. So once again, the state of New Jersey is representing is the plaintiff. The defendants are or the what we call part itself. The plaintiffs are the Patterson, New Jersey. The defendants are the state of New Jersey and the Attorney General, because the Attorney General represents the state of New Jersey. And the appellate court, the appellees are Patterson, New Jersey, and the respondents are the state of New Jersey and the Attorney General. Very important to see who's positioned, who's playing what. Okay. Now it's mighty strange that the the defendants or the respondents are the state and the plaintiffs or the appellates are Patterson. And we know Patterson is a municipality in the state of New Jersey, out of all the municipalities, that was named after William Patterson. Okay? William Patterson. Okay? William Patterson was the one who overthrew the crown by replacing William Livingston. Okay? William Livingston was a royal governor under the authority of the crown as set forth by the crown in 1702 as well as in 1776. All right. It's very important to understand what it is that I'm trying to explain to you because most of us are ignorant in this matter. All right. Let's get to it. Let's look at Patterson first. Patterson, New Jersey. Patterson, New Jersey. Named after William Patterson. All right. Named after William Patterson. The government structure of Patterson, New Jersey, or the county or municipality of Patterson is under what they call the Faulkner Act, okay, which is what they call an optional charter, okay? It's an optional charter under the Faulkner Act, all right? It's called a home rule, all right? It's called a home rule, named for William Patterson, okay? William Patterson. So the municipality is in the state of New Jersey, and the state of New Jersey claims to have supersession power over the municipality, which both has their charter. Okay, one was incorporated based upon the administrative government that was transferred from the 1844 Constitution to the 1947 Constitution, which they're using neither. They're using administrative codes under quasi-legislative and upheld by quasi-judicial enactments. Okay, we must comprehend. If you can't comprehend, then you will not understand this lesson. All right. It's named from William Patterson. Who is William Patterson? William Patterson. Let's see his career. War fought in the American Revolutionary War. Okay. Commissioning officer, Continental Army, United States Colonies of North America. Educated in Princeton University. Political party Federalist. Died in Albany, New York. Born in County Antrim, Ireland. All right. Succeeded by Joseph Bloomfield He was preceded by Governor William Livingston. Okay, and he was the Attorney General. The Attorney General prior to William Patterson was William Livingston. Okay, William Patterson went on to become United States Senator from New Jersey, and then he went on to become governor of New Jersey. Very important term, governor. We're gonna look at that. Then Associate Justice of the Supreme Court of the United States of America. All right. I hope everybody's following along. Now let's go back to the court case because we see William Patterson, which Patterson is named after, was the one who overthrew the crown property was overseen by the world governor William Livingston, who was the illegitimate son of William Franklin. Okay, and he fought on the side as a loyalist. Okay, and he the one who gave the two-vote speech to the administrative of New Jersey, i.e., the General Assembly and the Council, about the two roles that they have in regards to the choices that they're going to make, which we call they cast the dice, which means that they set a course which there's no return. Okay, let's move on. All right, so we see William Patterson replaced who? William Livingston. William Livingston was the governor at the time when the crown was in place. New Jersey Provincial Council. We're going to show you this before we go to the court case. New Jersey Provincial Council, or His Majesty's Council for the province of New Jersey. This went from the Witten, or what we call Wittemont, to what we call the Korea Regis when William the Conqueror invaded England, to what became known as the Department of England when it was taken over by the Plantagenet kings, Henry II, Henry III, Edward I, Edward II, Edward III, as well as when it came under what we call the King's Bench. Okay, that King's Bench then was switched to what we call New Jersey Provincial Council, which was still operating under the King's Bench, okay, which was that place which was in place at that particular time, okay. So we see that New Jersey Provincial Council, His Majesty's Council for the province of New Jersey, was the upper house of New Jersey's legislature under the colonial rule until it was replaced by New Jersey's Legislative Council under New Jersey's Constitution of 1776. All right. The time span is from 1702 to 1776. And the last world governor in 1776 was William Livingston, who was placed by who? William Patterson, where Patterson Municipality was named after, which where the police department is situated, which now was superseded by the state of New Jersey, where Patterson is situated by the governor and the attorney under the attorney general by the attorney general under the authority of the governor in lieu of what they call the power of superseding or supersession. If everybody understand what I just said, please give me a thumbs up in the chat. Okay, as I read. History. The Provincial Council was established in 1702 upon the surrender by the proprietors of East Jersey and those of West Jersey of the two colonies of the province of New Jersey, a royal colony, established a new system of government. The instructions from Queen Anne to Viscount Cornbury to the first world governor of New Jersey outlined a fusion of power system which allowed for an overlap of the executive, legislative, and judicial authority, and provided for bicameral legislature consisting of a council and general assembly. If we look at New Jersey's 1844 Constitution and 1947 Constitution, it clearly shows you that there was a separation of powers. New Jersey's 1844 Constitution and New Jersey's 1947 Constitution shows you that there was a separation of power, but that's not our focal point. Our focal point is New Jersey's Constitution of 1776, because we know from 1702 to 1776, the authority that they were operating under was what they call the Crown. Okay, the Crown, and it was an attendant court that was seated either in Burlington or Perth Amboy. Wherever the king went, his court went with him. Okay, wherever the king went, his court went with him. Okay. On December 6, 1775, Governor William Franklin paroled New Jersey legislator until January 3rd, 1776, but it never met again. On May 30, 1776, Franklin attempted to convene the legislature, but was met instead with an order to New Jersey Provincial Congress for his arrest. On July 2nd, 1776, the Provincial Congress approved the new Constitution. On August 13th, a new legislature was elected and appointed the provincial council, being succeeded by elected New Jersey new legislative council. Okay, so you see the transitions taking place. They said that Governor William Franklin was the son of Benjamin Franklin. I had it wrong in regards to the state of New Jersey. William Livingston was not the son of Benjamin Franklin. I correct myself. All right, let's go back here real quick. William Livingston. Let's just look at this one more time before I move on. William Livingston was succeeded by William Livingston. Okay, let me pull him up real quick. Okay, William Livingston was the first world. Yeah, that's right. He was the first governor of New Jersey. Okay, William Livingston was the first governor of New Jersey who was succeeded by William Patterson. Okay, we understand that um, William Franklin was arrested by New Jersey's Provincial Congress as a result of their overthrow of the Crown's government. Okay, so once again, William Livingston and William Franklin are two different people. William Livingston was the first governor of New Jersey, and we see that William uh, uh, Franklin was replaced by William Patterson. Okay, let me just make sure I know what I'm talking about. All right, William Livingston replaced William Patterson. All right, which was the first world governor. Let's go back to Patterson. William Patterson. All right, so yes. So William Livingston was the first governor of New Jersey, and William Patterson was the second governor of New Jersey. Okay? William Livingston was the first governor of New Jersey, and William Patterson was the second governor of New Jersey. Okay? Now, when we go back to New Jersey Provincial Council, let's go back there now, since I made the correction. Go right back here. Make the connection. On December 6th, Governor William Franklin prorogued the New Jersey legislature until January 3rd, 1776, but it never met again. Okay? So who replaced William Franklin? Let's click that. I think we're going to come up with William Patterson. Yes. Okay. All right, yes. So William Franklin was succeeded by William Livingston as the governor of New Jersey. Okay? You see it? Everybody see the connection? So from William Franklin, all right, the illegitimate son of Benjamin Franklin, when he was arrested, he was then succeeded by William Livingston as the first governor of New Jersey. Then he was succeeded by who? William Patterson, where Patterson municipality is named after, which is the plaintiff in the complaint we're going to read about, which was incorporated in the state of New Jersey by the municipal charter, i.e., the Faulkner Act, which is optional charter, and the state of New Jersey incorporated based upon statutory incorporation under Title 52 of the New Jersey Revised Statute. Okay, so from William Franklin to William Livingston, from William Livingston to William Patterson. Okay, there's the connection. All right. Now we can go to the case law. Approved for publication December 18th, 2024. Mirza M. Balur, in his official capacity as the acting public safety director for the City of Patterson and Appropriate Authority, City of Patterson Police Department, and Engelbert Ribeiro, in his official capacity as the police chief of the City of Patterson Police Department, plaintiffs and appellate. Versus New Jersey Office of the Attorney General, Matthew J. Platkin, and his official capacity as the Attorney General of the State of New Jersey. Okay? Defendants and respondents. Okay? There's also other parties who joined as well. I'm not going to read their names. All right? The opinion of the court was delivered by Judge of the Appellate Division, Judge Smith. All right? Hold that thought. Soon after a tragic incident, a Patterson concerning a officer involved shooting. Parts out. Soon after a tragic incident in Patterson concerning an officer involved shooting, Attorney General directly superseded or took over the entire Patterson Police Department without the consent of the city officials. The Attorney General removed the acting police chief and reassigned him to a position at the Police Training Commission. Part so. The Attorney General removed the acting police chief and reassigned him to a position at the Police Training Commission. In the chief's place, the Attorney General appointed an officer in charge, IEOC, to manage the day-to-day administration and operation of the department. Plaintiffs challenged the Attorney General's supersession and two lawsuits asserting the Attorney General's action is taking over the department and unilaterally removing the duly appointed chief of police was ultra-virus. Okay? Was ultra-virus. All right? So that was this was the argument brought before the court, the appellate court. All right, on review. It went before the district court, which ruled in favor of these so-called defendants in the matter, but it was overturned in the appellate court. All right, and we're going to read the review or the opinion or the dissent of the judge in lieu of the reversal in favor of what we call the plaintiffs or the appellants. Let's go down. I highlighted it so we can get right to the meat. Everybody pay attention. However, when the agency interprets a statute or case law, a court will reveal that interpretation under a de novo standard of review, which means from the beginning, all over again. Using this principle as a guide, we proceed with a de novo review of the defendant's administrative actions. When they say defendants, they're talking about the respondents, i.e., the Attorney General and the state of New Jersey, versus the plaintiffs, i.e., the appellants, the Patterson Police Department, and their and the claimants. All right, very important. So this case is being reviewed de novo by the appellate court of the state of New Jersey. Defendant's timeline argument. Okay. As a threshold matter, defendants argues plaintiff's challenge to the attorney's office of the attorney general's supersession is untimely, which means that they're dealing with what we call statute of limitations or time barment. Okay, didn't file in a certain amount of time. Okay, so it says defendants give two reasons for their argument, i.e., the state of New Jersey and the attorney general. It's never based upon an evidence presented by them. There's always some technicality that they want to give off. They never want to really argue a matter, especially when it's against them. Okay, when they're prosecuting somebody, that's a whole nother story. But when it's against them, they already want to move from some dismissal from some technical matter, or you failed to state a claim, or you didn't file the claim in a certain amount of time. This is always where they go. Not this time, brothers and sisters. All right. Defendants give two reasons for the argument. Plaintiffs failed to comply with the 45-day rule. Okay, a 45-day rule that they created themselves in regards to bringing the claim against the state or the attorney general acting outside of their capacity and what they call their so-called claim of immunity. Okay. So it says that plaintiff failed to comply, i.e., this will be Patterson, with the 45-day deadline to challenge final administrative decision under Rule 2:4-1B. And plaintiff's appeal is barred by latches. First of all, their appeal might be barred by latches, but not the king. Okay? Why? Under what we call nullum tempus ericet rege. Eric Parcel. Nullum tempus ericet reggae, okay, which means that for the king there is no time bar, okay? For the king there is no time bar. It may be for you because you created the statute of limitations as well as a what we call latches, all right, to prevent people from bringing claims when they realize some damages or some wrong has occurred, okay? We must understand that, all right? Let's look at the term nullum tempus accurat reggae. Nullum tempus accurat reggae. No time runs against the king. Also abbreviated to nullum tempus, is a common law doctrine. In republic is often referred to as nullum tempus accurat republicae, right? The doctrine states that the crown is not subject to statute of limitation or to doctrine of latches. This means that the crown can proceed with actions that will be barred if brought by an individual due to the passage of time. It also makes it impossible to obtain property rights over government-owned land by adverse possession or through squatter rights. The doctrine is considered by some to be an application of sovereign immunity to areas of law concerning statutes of limitation. While the two doctrines are often linked as a concept and are considered by some jurisdictions to be intertwined in policies and practice, there is a debate of whether the two doctrines are actually related. So on the nullus tempus accurat reggae, there is no time bar based upon the statute of limitations or latches, okay, for the king. But the state of New Jersey, as well as the Attorney General, are moving for dismissal based upon those latches that they claim that the plaintiff didn't meet their time limitation in regards to breaking the claim in lieu of some type of claim that they can bring to a party on behalf of failure to act, all right, i.e., nonfeasance of office. All right, let's get to it. Defendants Rule 2:4-1B arguments raise three questions. Whether the actions of the Attorney General and the Office of the Attorney General administrative decisions. Once again, Defendant Rule 2:4-1B arguments raise three questions. Whether the actions of the Attorney General and the Office of Attorney General are administrative decisions? Question mark. If so, were these decisions final? Question mark. If these decisions were final, are plaintiffs' challenges barred by timeline consideration? Question mark. Okay? Those were the three questions that the appellate court had to review in regards to the defendants or respondents' arguments that were brought before the appellate court. All right. Defendants Rule 2:41B arguments, yeah, we read that. Okay. It said first we would consider whether defendants' actions were administrative decisions, and if so, what type. We noted that once again. You're right, Countess Walker, unconstitutional acts. We first consider whether the defendants, i.e., the state of New Jersey or the Attorney General, or acting under the authority of the governor by way of what we call claiming to have the right to supersede, called supersession of Paterson, New Jersey, okay? Which prior to them even coming into existence, that territory, i.e., that property, which is called land, i.e., real estate, was under the authority of the crown, okay? So it said we first considered whether the defendant's actions were administrative decisions, and if so, what type. They noted in the appellate court's decision, let's read it. Most administrative agencies perform two delicate functions. They have the power to make rules that can have the effects of law, a quasi-legislative role, and the power to adjudicate individual cases, a quasi-judicial role. Did y'all hear that, brothers and sisters? Did you hear that? Let's look at quasi-judicial and quasi-legislative before we move forward, okay? If you don't understand what that means. Quasi-legislative. Let's define that. See, this is how you should teach. Just don't read, break it down. Break it down. Quasi-legislative capacity. A quasi-legislative capacity is that in which a public administrative agency or body acts when it makes rules and regulations. When an administrative agency exercises its rule-making authority, i.e., quasi-judicial, quasi-legislative or quasi-executive, all right, through the executive department, which are administrative government overseen by the governor or the president. When the administrative agency exercises its rule-making authority, it is said to act in a quasi-legislative manner. Administrative agencies acquire this authority to make rules and regulations that affect legal rights through statutes. This authority is an exception to the general principles that law affects rights to be passed only by who? The elected lawmakers. Did y'all hear what I just read? If everybody understand that, please give me a thumbs up in the chat line. Everyone, give me a thumbs up in the chat line if you understand what quasi-legislative capacity means. All right, because this is what the state as well as the municipality are acting under. All right. Overview. Administrative agency rules are made only with the permission of elected lawmakers. An elected lawmaker may strike down the administrative rule or even eliminate an agency. In this sense, quasi-legislative activity occurs at the discretion of the elected officials. So they allow this, excuse my French, shit to go on. Nevertheless, administrative agencies create and enforce many legal rules on their own, often without the advice of lawmakers, and the rules have the force of law. This means they have binding effect on the general public. Y'all better listen to what I'm trying to explain to y'all. So that's quasi-legislative capacity. Let's look at quasi-judicial body. Because this is the power that the state and the municipality have. Okay? And they are pissed off at each other because they're both are breaking the quasi laws that they created, which is actually a violation of law in the first place. Okay? Quasi judicial body. A quasi judicial body is a non judicial body. What? A quasi judicial body is a non judicial body which can interpret law. It is an entity such as an arbitrational panel or a tribunal board, which can be a public administrative agency, but also a contract or private law entity, which has been given power and procedural resembling those of a court of law or judge, and which is obliged to objectively determining facts and drawing conclusions from them so as to provide the basis of an official action. Such actions are able to remedy a situation or impose legal penalties, and they may affect the legal rights, duties, or privileges of specific parties. Y'all better pay attention. I hope the governor is paying attention. I hope the attorney general is paying attention. And I hope that prosecutor in this criminal case is paying attention because y'all is in a world of trouble. All right. I didn't say it. The appellate court said it, and the Supreme Court gonna say it. So don't even need to go to the Supreme Court because I already know what they're gonna say. Right? We're gonna show you. This is what the appellate court used to make that decision to the to make this statement or the dissent or the argument that you have overseeded your power. Okay? Supersession or superseding, no matter what you use. All right? So quasi judicial body for quasi legislative uh 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 quasi judicial body for quasi legislative capacity, those who have them that was actually given to them or executed to them by what we call the executive government. Let's look at that before we move back to the case law. Executive government. The scope of the executive powers varies greatly depending on the political context in which it emerges. It can change over time in any given country. In democratic countries, the executive often exercises broad influences over national politics through limitations and are often applied to the executive. Remember, Article 3 of New Jersey's Constitution, 1844, and Article 3 of New Jersey's 1947 Constitution clearly states that there are a separation of powers. We're talking about the state. We didn't even mention this, the United States Constitution about the separation of powers. Okay, so we must understand the difference between quasi-legislative concepts and quasi-judicial bodies that actually got their authority from the executive department, headed by either your president or your governor, which is not the proper name for them. Okay, it's not the proper name for them. We're going to talk about that in a second. Let's go back to the case law. So most administrative agencies, this is what the appellate court said, perform two delegate functions. They have the power to make rules that can have the effect of laws, a quasi-legislative role, and the power to adjudicate individual cases, a quasi-judicial role. Case law to support it. The line, the line between the two functions, however, is not always a clear one. Okay? The line between the two administrative, the line between the two functions, however, is not always a clear one. Agencies can also act in a hybrid manner, okay, with features of rulemaking and adjudication or in an informal fashion without a hearing, okay? This is called a bench trial, okay? A bench trial. Let's move further. Defendant's supersession of the entire police department and reassignment of chief of bureaus contains both quasi-legislative and quasi-judicial elements. The actions reflect an administrative policy that was not previously expressed in any official or explicit agency's determination and a decision on administrative regulatory policies in the nature of interpretations of law. We first identified the Attorney General's quasi-legislative act. Okay? So this is what they deal with first. We first identified the Attorney General Quasi-Legislative Act. In March 2023, defendants assumed plenary control over the administration and operations of the Patterson Police Department, including installing new management by appointing a OIC. Defendants have not previously taken such unilateral action against the city entire police department force. In support of the supersession, defendants cite the Criminal Act of 1970. Okay, they cite the Criminal Act of 1970, New Jersey statute annotated 5212B-97 to 117, New Jersey, as well as New Jersey statute annotated New Jersey statute annotated 2A colon 158-4 and dash 5, as well as relevant case law. The Attorney General then interpreted the statutes and precedents to authorize to possession of passing the entire police department. Defendants' actions in this instance are quasi-legislative in nature, and they reflect the Office of the Attorney General rulemaking functions. It follows the plaintiff's challenge to this aspect of defendants' actions and are not governed by a 45-day rule. We next access defendants' quasi-judicial acts. Okay? Now we deal with the defendant's quasi-judicial acts. This is the appellate court we're talking about. When determining whether an agency decision is quasi-judicial act, the crucial question is whether the fact finding involves a certain person or persons whose right will be directly affected. Okay? Indeed, agencies engaged in quasi-judicial decision making must consider evidence and apply the law to facts as found, thereby exercising a discretion or judgment judicial in nature on evidentiary facts. The nature of the factual inquiries may be dispositive or assist in disposition of the issue. Okay? The Office of the Attorney General reassignment of Chief Barbario and OIC opposites unilateral execution of the MOU on November 15th represents agency decisions involving a person whose right will be directly affected. These two decisions represent quasi-judicial actions which, if final, are subject to the 45-day rule. We only review the final actions of the agencies pursuant to the New Jersey statute annotated 52 14B 12 rule, as well as Rule 2 2 3A Section 2. The agency's decision must convey unmistakably notice of its finality. Okay? The agency's decision must convey unmistakably notice of its finality. Pardon yourself, this mouse is crazy. Of its finality. While defendants' actions were not derived from formally entered judgments, the record shows they gave clear and unambiguous notice to the city officials and residents alike that their decisions were final. The Attorney General first communicated suppression of the entire police department to the mayor by a letter dated March 27, 2023. Okay? March 27, 2023. The opening paragraph of the Attorney General's letter stated, and I quote, I write to provide you with notice that I am exercising the supersession authority of my position, and the Office of the Attorney General or AG has assumed responsibility for the day-to-day operation of the Patterson Police Department, inclusive of its internal affairs and functions. I have appointed Issa Abbasi to serve as the officer in charge, OIC, effective at a date to be determined in May of this year. Effective immediately and until such time the officer in charge, Abbasi, assumes command of the police department. I have named Major Fred Fife of New Jersey State Police as the interim of the officer in charge. He is the other member of the Office of Attorney General staff and will be temporarily assigned to Patterson to work with current members of the Patterson Police Department to ensure that there is a continuity of the police services in the city. The Attorney General March 27 letter communicates unmistakably notices of finality to Mayor Sahi. First, the letter plainly states that the Office of Attorney General immediately assumed daily operational responsibility for the city's police department. Second, the letter clearly describes the scope of the takeover, informing the mayor that defendants assumed responsibility for an entire police department, including the internal affairs. Do y'all hear this? These elements of the letter, along with the Attorney General's notice that an officer in charge would assume command of the police department, represents the consummation of the agency's decision-making process. Okay? It's right there. Yes, I read through this whole case. Advancing their latches, defense defendants contends they are prejudiced by plaintiff's delay in filing the first complaint. Defense insists that prejudice is financial, arguing that they invested millions of dollars on Patterson public safety initiative that they may not have spent but for the supersession. So if they justify their supersession by the progress that they made in the city of Patterson, which was done unconstitutional. Why? Because you were not supposed to be acting in that capacity, which we're going to discover as we go on through this lesson. Okay? You were not supposed to be acting in that capacity. So it says, advancing their last defenses, defendant contended that they are prejudiced by plaintiff's delay in filing the first complaint. Defendant insists the prejudice is financial, arguing that the investment of millions of dollars on Patterson public safety initiatives that they may not have spent, but for the supersession. We We are unpersuaded and decline to consider defendant's public expenditures and Patterson's as part of the latches analysis. So they said they ain't moved by this argument. They're not moved. Even if latches did apply and we conclude it does not, we would hear this appeal on the merits in view of the importance of the public question that's involved. Okay? We must understand what's going on. If everybody like what you're hearing so far, please give me a thumbs up in the chat. The Attorney General's supersession authority. The Attorney General's supersession authority. The parties agree that the dispositive question is, does the Attorney General have legislative or other authority to supersede an entire police department without consent of the municipality? We resolve the question by defining supersession, then reviewing relevant legislation, administrative actions, and case law concerning supersession. Okay? We already defined it. Now let's define it. Let's see how they define it. Definition of supersession. Our first task is to define supersession. The term superseded, and supersession appear in New Jersey Statute 52:17B-106 and 107. But they are not defined by any statute or regulation. Where terms are not defined by statute or regulation, we afford those terms their generally accepted meaning according to the approval uses of the language. The dictionary definition of supersession is the act of superseding or the state of being superseded. The state of being taken over. Merriam-Webster Collegiate Dictionary defines it that the present tense of superseding and superseded is supersede, which is defined as to cause to be set aside, to force out of use as inferior, to take the place or position of, or to displace in favor of another. With this definition in mind, we consider how the term has been used by the legislator and by the defendants. Everybody see that? Now we heard that the Attorney General said he's gonna go to the Supreme Court to see if he can get the matter overturned, which was reversed by the appellate court. All right, that ain't gonna work. Supreme Court already made their decision, and decision that they gave in the Supreme Court, you ain't gonna like. The appellate court was nice with their dissent. When the Supreme Court get their dissent, they gonna keep it real. Make sure I didn't miss nothing. I got some more down here. I read, my brothers and sisters. I study. I put in the work. So if I can do it, you can do it. Okay? If you can do it and I can do it, that means we can do it. So if I can do it, we can do it, then let's all do it together. We also address state versus wine, which is the Supreme Court, which we're going to go to in a second. Okay? So they already addressed the Supreme Court in regards to this matter that's being heard in the appellate court. So why are you going to the Supreme Court for when knowing they're going to agree with the appellate court? In wines, our Supreme Court held that county prosecutors are statutorily responsible for seeing that detection, arrest, indictment, and conviction of offenders against the law are done either by himself or his staff or by local law enforcement authorities functioning within his county. The court acknowledged a county's prosecutor's powers over local law enforcement authorities to fulfill these official duties. It is a matter of common knowledge that the local law enforcement authorities are responsive to the county prosecutor's concept of law enforcement on pain of possible indictment. If they do not cooperate with him enforcing that law, he is in a position to command the cooperation of all law enforcement authorities in the county. The court concluded that an indictment of common law nonfeasance against a local county prosecutor was not flawed because it clearly set forth the prosecutor's breach of their official duties under New Jersey statute annotated 2A:158-5. That's 5. The facts of this case are distinguishable from Wien, i.e., the Supreme Court. The set of questions before us involve the extent of the supersession authority vested directly in the Attorney General, not the county prosecutor. Win does not stand for the proposition that county prosecutors have the implied authority to supersede municipal police departments, and our holding, i.e., the appellate holding, stated that the Attorney General does not have the legislative authority to supersede municipal police departments without their consent, pose without their consent, pose no conflict. Possess poses no conflict. You hear that? This is the appellate court for the state of New Jersey, and they're made their dissent based upon the state versus wine, which we'll go to now. All right. So that what the appellate court stated December 18, 2024, about the state of New Jersey. And we know the state of New Jersey incorporated December 18th, 1787. Prior to that incorporation, all this was overseen by the king, who represents the crown, and those who operated off the authority of the crown was the king's council. Okay? All right? It was not the state of New Jersey which we're reading about. It was the state of New Jersey that was incorporated under the charter granted to them by the crown, okay? And that will be their constitution, okay? That will be their constitution because they incorporated the common law of England. How we know it? Let's go to it before we go to Supreme Court. Avalon. Constitution, July 7th, Constitution of Jersey, 1776. All right? We're going all the way down to Article 22 and 23. We're going to see it. We're going to see it from New Jersey's online website as well. Article 22, that the common law of England, as well as so much of the statutes laws as have been hereinforth practiced in this colony, shall still remain in force until they shall be altered by the future law of the legislator. Such parts only accepted as are repugnant to the rights and privileges contained in this charter, and that the estimable right of trial by jury should remain confirmed as part of the law of this colony without repeal forever. Article 23. That every person who should be elected as aforesaid to be a member of the Legislative Council or the House of the Assembly shall previous to his taking his seat of council or assembly take the following oath of affirmation. We already know about taking an oath. Their oath was A, and B do solemnly declare that a member of the Legislative Council or Assembly, as the case may be, of the Colony of New Jersey, I will not assent to any law, vote, or proceeding which shall appear to me injurious to the public welfare of the said colony. Nor shall annul or repeal that part of the 33rd section in the charter of this colony, which establishes that the election of members of the Legislative Council and Assembly shall be annual, nor that part of the 22nd section of that said charter respecting the trial by jury, nor that shall annul, repeal, or alter any part of parts of the 18th and 19th section of the same. And any person or persons who should be elected as aforesaid is hereby empowered to administer to the said members of the said oath of affirmation. Okay? Provided always in its true intent and in the meaning of that Congress, New Jersey's Congress, we're talking about, that if there was ever a reconciliation between Great Britain and the colonies should take place, and the latter be taken under the protection of the government of the Crown of Britain. It didn't say Great Britain, it said of Britain. This charter shall be null and void, otherwise will remain firm and inviolable. In the Provincial Congress of New Jersey, Burlington, July 2nd, 1776, by order of Congress, Samuel Tucker and William Patterson. Did you hear that? William Patterson. William Patterson is where Patterson Municipality is named after, who is the plaintiff in the complaint that we just read that was issued by the appellate court in regards to the power that the state did not have to revoke the charter of Patterson by what we call that term supersession. If everyone understand that, please give me a thumbs up in the chat line. All right. While you're doing that, we also want to pay close attention that the legislature of New Jersey amended this constitution September 20th, 1777 by substituting the word state in states for colony and colonies. Okay? We must understand how important I am to you, brothers and sisters. Okay? You must understand. Let's see. Let's look up right of possession, right of supersession again, real quick. I'll go on. Greetings, Brother Nunley from the House of Nunley. Glad you were able to join us today. Shout out to Archbishop Belmont. Everyone, show some love to my Archbishop. Send out some donations to help him out. You know what I'm saying? He does a marvelous work keeping the platform as well as the YouTube channel up and running. So all those who are able, please send your donations, gift grants, common sockets to the Third Temple English Church of England or to $ Clifford Jefferson L. All right. So your appreciation for us, it's well received. All right. So let's get back. Right of supersession, which we know that the state of New Jersey and the Attorney General and the prosecutor and the governor does not have. There are several rights in which there are several ways in which rights may be lost by renunciation or alienation, through wrongdoing or forfeiture, and through prescription, or the expiration of rights, or their expropriation by competing claimants. One form of prescription is supersession, which rights are alleged to fade away over time to be replaced by other claims of rights. So that's what we're going through. People claim or assume that the English rights have faded away over time. All right. Now they give you new rights. That's not what the Supreme Court of the United States versus One Kim Art said, and that's not what the um, uh, 14th Amendment said. All right. The 14th Amendment said that, in lieu of the Supreme Court, said that those who were emancipated by the 13th Amendment and became citizens by the 14th Amendment, that should be determined in light of the common law of England. If you didn't do that, then the other forms are methods to acquire your status in lieu of what we call your citizenship. All right. So we must examine those ways before we make a proper um, claim on or identity of who we are, because for us, status under the common law is based upon the legal uh, definite parts of the status under common law for us as English national is determined by the legal relationship of our actions behavior, which establishes our legal status under the common law of England. Okay, very, very, very important for you to comprehend that. All right. So we see. I'm going to go back here for a second because we missed something. We all have missed something. We all guilty of this. All right. And I just found this today. Okay. I just found this today. New Jersey's Constitution. (1776). We read it on Avalon. Now we're going straight to the department. All right. Right to New Jersey State Department. 1776 Constitution. On July 7th, July 2nd, 1776, New Jersey became the fourth American colony to adopt a constitution declaring independence from Great Britain. It was composed in 5 days, and although the delegates considered it a temporary charter, temporary, brothers and sisters, provisionary, a provisionary charter, it remained New Jersey state constitution for 68 years later. 1776 plus 68 is 1844. 1776 plus 68 years is 1844. All right. So we understand that the Constitution or the Charter for New Jersey in 1776, July 2nd, was one, temporary, two, it remained in effect for another 68 years. Okay. All right. It's temporary, but it remained in effect for another 68 years, and it was operating under what we call the Crown. Okay, because the law that was governing in that under that charter was the common law of England, based upon Article 22 and Article 23. Okay, we must comprehend that. But what we need to look at is the Article 1. Article 1 tells it all, my brothers and sisters. Let's look at it. Article 1 tells it all. That the government of this province shall be vested in a governor, Legislative Council, and General Assembly. This is what Viscount Cornbury told all the acting governors under the government that was instituted under Queen Anne, that was known as the government of the crown. The government of the crown. You hear that? And who was in charge of the government of the crown? Article 1 said it, that the government of this province should be vested in who? The governor. So that's the one we need to go to. The one you see right here. He's the one who started all this mess, and he's the puppet. Okay? How we know it? Let's look at it. They are acting under non-feces of office, malfeces of office, and misfeces of office. Okay? It's very important for you to understand that. Let's look at what these terms mean before we go forward. Malfeces, misfeces, and non-feces. Okay? Malfeasance is in office. Malfeasance in office is doing of an act for which there is no authority or warrant of law. I repeat, malfeasance is malfeasance in office is doing of an act for which there is no authority or warrant of law. Misfeasance is the wrongful and injurious exercise of lawful authority, that is the doing of an act which might lawfully be done, but is done in an improper manner. And nonfeasance is a term used in tort law to describe in actions that allow or result in harm to a person's or to property. An act of nonfeasance can result in liability. One, the actor owed a duty of care towards the injured persons. Two, the actor failed to act on that duty. And three, the failure to act resulted in injury. Okay? It resulted in injury. We as a people are injured. Why? Because the state of New Jersey and their officials who work for the state of New Jersey, i.e., the governor and attorney general, have superseded their authority by what we call supersession. Okay? By way of supersession. And this is a non-feces, malfeces, and misfeasance of office. Okay? All right? They have violated the law. This is why we have taken our position. Okay? I'm going to show you before I move forward. Superior Court, New Jersey, Transfer Division, Mrs. County, Civil Action, docket number MIDC 000-143-24, letter to the Chancellor, right of supersession amended. The complaint was the letter to the notice to the judge was already filed, but I had to amend it to twerk it a little bit. All right, this should be filed on Monday. I'm just going to read a little excerpt of it. All right. And when I write these letters, they're to the court, not to the defendants. I'm actually talking to the chancellor. All right, Lord Chancellor, keep up the king's conscience. I'm speaking directly to him. All right, communicating with the court in lieu of the argument that was brought before the court, in lieu of the complaint filed by I, your king, and the Crown of England on the state of New Jersey and the land New Jersey Land Title Institute, and anybody else who got something to say in regards to acquiring this title on the land that actually belongs to us. All right, because New Jersey superseded their position by claiming the right of supersession, i.e., superseding by way of what we call prescription, okay, acquisition, alienation. Okay, we know this already. His Majesty King Clifford Jefferson submitted this letter to the presiding judge in this matter. The defendants have no right of suppression of the Crown land, now known as the state of New Jersey. New Jersey's Constitution, blase, blase, blase. All right, which are the articles that we're making reference to right here. The, The governor also termed viceroy, minister, or regent in his acting officers' cast of die is evident, i.e., the cast of die, it means to set a course of events from which there is no return. So the governor also termed viceroy, that's another word or another term or a synonym for the word governor. Viceroy, minister, or regent in his acting officers' cast of the dice is evident, being regents of the crown of England. In a monarchy, a regent from Latin regens ruling governing is a person appointed to govern a state pro tempore, i.e., temporary, as established in Article 23 of the Constitution of 1776, a provisionary, because the actual monarch is a minor, absent, or incapacitated, or unable to discharge their power and duties, or the throne is vacant and a new monarch has not yet been determined as established in Article 23 of the 1776 Constitution of New Jersey. Okay? We must understand what's going on. The governor is a regent, also termed minister, and the viceroy of the crown. All right? That's what he is. How we know this? Look at some synonyms for the word regent. Okay? Let's look at some synonyms. Regent. A person who governs a kingdom in a minority, absent, or a disability of the sovereign. You hear that? A person who rules or reigns. Governor. A member of a governing board or a state or of a university. Once again, a member of a governing board at a state of a state university. Okay, so that's the definition. I mean, that's a synonym for the word or the term regent. Okay, governor means the same as regent. How many of you brothers and sisters do that? Okay, let's look at what the 1911 Encyclopedia Britannica says for regent. Regent. One who rules or governs, especially one who acts temporarily as the administrator of the realm during the minority or incapacity of the king. The latter function, i.e., incapacity, is rarely seen. Okay, so it says that regent one who rules or governs, especially one who acts temporarily as the administrator of the realm during the minority or incapacity of the king. The latter function, however, is one unknown to the English common law. So there should be no incapacitated king. Okay? That's unknown to common law, but since they don't follow the common law, this is the reason why it's unknown. In judgment of the law, the king as king cannot be said to be a minor, for when the royal body politic of the king does meet with the natural capacity in one person, the whole body shall have the quality of the royal politic, which is the greater and more worthy, and wherein is no minority. Did y'all hear that, my brothers and sisters? Did you hear that? Regent, one who rules or governs, especially one who acts temporarily as an administrator of the realm during the minority or incapacity of the king. The latter function, however, is one unknown to the English common law. In judgment of the law, the king as king cannot be said to be a minor, but when the royal body politics of the king does meet with the natural capacity, i.e., personification, incorporation, incarnation, all right, that's what I did. Corporation soul. When they meet with the natural capacity of that natural person, the whole body shall have the quality of the royal body of politics, which is greater and more worthy, and wherein is no minority. But for the reason of necessity, a regency, however anomalous it may be in strict law, has frequently been constituted both in England and Scotland. The earliest instance of the English history is appointed of the Earl of Pembroke with the assent of the lower barons of the accession of Henry III, the son of John, the son of Henry II, the son of Godfrey, the fifth Count of Anjou, son of Fulk, ruler of Jerusalem. Let's look at governor from the 1911 Encyclopedia Britannica. Because you got to be sure. I want y'all to be sure about the choices that y'all make. Governor, 1911 Encyclopedia Britannica. Governor, from gouverneur to gouverneur, or governor, Latin gouverneur. This is where you get your gubernational, i.e., your state congressional elections. They're called gubernational elections. Okay, so it says to steer a ship, to direct or guide. In general, one whom governs or exercises authority, specifically an official appointment appointed to govern a district, province, or town, and etc. In British colonies or dependencies, the representative of the crown is termed a governor. Colonial governors are classed as governors generals, governors, and lieutenant governors according to the status of the colony of, or group of colonies over which they preside. Their power varies according to the position which they occupy. In all cases, they represent the authority of the crown. How many people understand how important this is? All right. How many of you understand how important it is that what I'm doing for y'all? All right. So as we see what region and governor means the same based upon 1911 Encyclopedia Britannica, because a lot of you don't trust Wikipedia. Now let's see what Wikipedia has to say about region. Region. In a monarchy, a regent, ruling governing, is a person appointed to govern a state pro tempore for the time being, because the actual monarch is a minor, absent, incapacitated, or unable to discharge their powers and duties, or the throne is vacant, i.e., interregnum. Let's see what it says. Interregnum. I know my stuff. And a new monarch has not yet been determined. The rule of the region of or regions is called a regency. Now they call them what they call uh uh they call it when you go overseas. They call it when you go overseas. Uh, what they call it? Consul, not consul court. What they call them? Uh, somebody help me out. Embassy. Okay, they have embassies now set up. All right, so the rule of regents or regents is called regency. A regency or regency council may be formed ad hoc or in accordance with a constitutional rule. Excuse me. Regent is sometimes a formal title granted to a monarch, most trusted advisor, or personal assistant. If the regent is holding the position due to their being in a line of succession, the compound term is prince regent and is often used. If the regent of a minor is in their parts of. If the regent of a minor is their mother and she is a wife or widow of the king, she will be referred to as a queen regent. Okay, so do you see it? Regent and governor, it's the same, are synonymous. They also mean the same as viceroy or minister, okay? All associated with the church, okay? All associated with the church. All right, let's see. Let me show you here. Show you that I don't play, brothers and sisters. Here go the docket. Look at that. Complaint filed by King Clifford Jefferson and the Crown of England. Correspondence uploaded by case management staff submitted by King Clifford Jefferson and the Crown of England. This is what we're talking about today. Right of suppression. All right. So I'm covering everything. I'm going right at their throat. Quiet title equity. Okay. How many of your leaders have done this? All right. How many have addressed the the important facts, the important arguments that are needed to be able to bring solutions and to the field release that we seek in this day and time? We must comprehend that. And the only way we can comprehend that is to have the same uh, um, overstanding as what the appellate court stated about the state of New Jersey and the Attorney General in lieu of concerning the state and Patterson municipality. And we're going to see the same interpretation in the Supreme Court by what we call the state versus wine, okay, which is in closing. All right, which is in closing. State versus wine. State of New Jersey, uh, plaintiff appellant versus Walter G. Wine, defendant responded. The Supreme Court of New Jersey argued March 2nd, 1953. Okay? So there's no need to go to Supreme Court to appeal what the appellate court said in regards to the reversal of the supersession or superseding authority that you claim to have. All right? There's no need to go to the state versus Supreme Court of New Jersey because they're going to tell you right here. All right? You read right past that and the dissent given by the appellate court. You just overlooked that. Like Countess Phoenix said, yeah, he looked nervous. All right, so this is in closing, my brothers and sisters. State of wine. Supreme Court of New Jersey argued March 2nd, 1953, decided March 30th, 1953. All right. The opinion of the court was delivered by Chief Justice Vanderbilt. Okay. I read a lot of his cases. That was a good judge back then. Word is born. He was GP. All right. Everybody love what you're hearing? Give me a thumbs up in the chat. Let's get it. Yeah, I just want to let y'all know I went to I went to I had the post arraignment hearing on the 9th of this month. And at the hearing, the prosecutor, I mean parts of the public defender, both of them, I got two of them. None of them want to take the case. This is exactly what they told me. Mr. Jefferson, uh, we're going to be honest with you. Uh, your argument, we can't raise this argument in this courtroom because you raising arguments return to the common law, and this we're not practicing the common law in this courtroom. And he straight up told me, Like I said, I can understand that. I understand that it's a conflict of interest. I understand uh, your concern in regards to exposing this before the court. I said, but I'm not here to defend you nor the state. I'm here to defend the common law because without the common law, we don't have any protection. Okay? He said, I said, so if you can't do it, then you need to appoint or have a court appoint somebody that would defend my status under the common law. He said, that's the problem. Ain't nobody gonna take your case. I said, well, that's not for you to decide. That's for the court to decide. I said, well, so I said, well, I heard him out. I said, well, what I said, well, I'm open for suggestions. So if you can make this matter go away without having me to take a plea, then I'm open to your suggestion. He said, yeah, we can possibly make this trial go away without you having to plea. So I said, no problem. I'm open to hearing what you had to say. He said, we have a program for you. So when the public defender stood before the court, they said, yeah, my client pleads not guilty, and the prosecutor and I agreed that he might qualify for the specific program. And so I got a phone call last week. I think it was last Friday, and it was from a drug program, right? A pre-screening. I'm like, yo, I didn't schedule for no or sign up for no drug program. They said, well, it was ordered by the court. I said, well, I never told the public defender that I would agree to something like that in regards to some type of stipulation or some type of program where I had to be subject to some type of encumbrances. So he said, well, I don't know what argument you talk you have with your public defender, but I was ordered by the court to do this. I said, well, I don't have a drug problem. I said, so there's need for me to come. He said, well, that determination will be made when you come down and see me. I said, no problem. So I went down. Come to find out, I don't even qualify for the program. So it backfired on the prosecutor and the public defenders to try to back out of this or try to remedify their predicament by way of creating this program or put me in this program, but I don't even qualify. So now they're going to have to defend this matter as planned. Okay, so I just give honor to our ancestors because they really are doing a marvelous job by putting these people behind the ball, and we're going to see it right here with the Supreme Court in closing. All right. So it goes on to say the opinion of the court was delivered by Vanderbilt Chief Justice. The defendant of the county prosecutor of Bergen County was indicted on November 28, 1951, on 19 counts charging with a criminal of nonfeasance in office. Now, we already know what they mean by nonfeasance. This is a tort, okay? We're not talking about malfeasance and what was the three of them? Malfeasance, misfeasance, and nonfeasance of office. All right, both of them are bad, but the third one is even worse. You know I'm real, brother. I don't play around. All right. So malfeasance, misfeasance, and nonfeasance. Okay, that's the argument. Okay. Thank you, Countess Cersei. The opinion of the court was delivered by Chief Vanderbilt. The defendants of the county prosecutor of Bergen County. When we talk about Bergen County prosecutor, we're talking about any prosecutor or any attorney general. All right, who are all over under the authority of what we call that governor. Okay, that governor. All right, and we're gonna see that governor, the attorney general, nor the prosecutor have does not have the power of what we call supersession or succeeding. Okay, you don't have that power. Okay, you don't have the power to act in the office and the authority in the office that you don't have. We're gonna see it. So let's read it. On June 30th, 1952, the defendant moved to dismiss the indictment, which is pretty much what the state uh, 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 um, while the state is not trying to get it dismissed, the state is trying to get the matter uh, reversed back into their favor because the appellate court ruled against the state in regards to the supersession authority and power they claim to have. So we see that the same argument that they're going to have as defendants in the matter, all right, um, the defendants in this case are having, which is going to be the case when my matter is brought before the chancellor. Okay, they're gonna have a hope in the world. All right, so let's read it in its entirety. On June 30th, and once again, when we speak about prosecutor in this case, we're talking about the prosecutor, the attorney general, and the case that was in the appellate court, as well as the prosecutor and the attorney general in my criminal case and in my chancery case. Okay, so it all amounts to this, that they are in fact going to lose. Let's see. So it says on June 30th, 1952, the defendant moved to dismiss the indictment. The trial court made an order on August 18th, 1952, granting the motion which the state seek to review here, i.e., the Supreme Court. All right. The first 16 counts follow a single pattern. They identify the defendant as the county prosecutor. They allege they have charged with a public duty of using all proper, reasonable, effective, and lawful means with his power and diligence for the detection, arrest, indictment, and conviction of offenses against the law. So it's the obligation of the attorney general, the prosecutor, to make sure that in that public capacity that they do the best to their ability to be able to uh, uh, in their public capacity to use all proper, reasonable, effective, and lawful means within their power and diligence for the detection, arrest, and indictment and conviction of any offender against the law. That includes them acting in their capacity as well. Okay? We must comprehend that. They charge that he had sufficient assistance and power to enforce the public duties enjoined in him by the law. So he had the authority to act, but he just did not act. Each of these indictments concludes by charging not only that the defendants knew these unlawful activities, but that he unlawfully and willfully did neglect and omitted to perform the said public duties so enjoined upon him, and then there continuously unlawfully and willfully did neglect, fail, and omitted to use and exercise and cause to be used and exercise all proper, reasonable, effective, and diligent means within his power as a prosecutor of Bergen County for the detection, arrest, indictment, and conviction of persons or persons who kept and maintained the gambling houses as aforesaid, wherein the practice of maintaining a resort to which person might come for any legal purposes, namely for the purpose of playing what? Dice, i.e., casting the die. You hear that? Casting the die. So in this case, since they were playing dice, the defendants, the attorney general, are playing the same thing. They're casting dice. They're taking a chance on matters without full knowledge of the matter that will come back to haunt them based upon their ignorance of what it is they're pursuing. Okay, so they are playing. They are taking chances. All right, they are taking chances. Well said. Casting lots. Okay, casting lots. Among the distinct crimes from which a public official may be indicted at common law are nonfeasance, misfeasance, and malfeasance in public office. The distinction between these three separate crimes relate to a familiar classification that not only runs through the law of crime, but the law of torts as well. Each of these three crimes has its own distinctive elements, and one is not to be confused with either of the other. The crimes of misfeasance and of malfeasance are mentioned here, not because they are involved in the law, but because of this argument, both here and in the trial court decisions dealing with the misfeasance and malfeasance of public office were relied upon as if they had been of nonfeasance, i.e., dealing with a tort. The basic question before us is whether nonfeasance in public offices are properly alleged in the indictment under our practice. In judging the sufficiency of the indictment, we must consider the official duties of the defendant, i.e., the prosecutors or attorney general. Okay? The prescribed duties of an office are nothing more nor less than the duties cast by law on the incumbent of the office. Duties may be imposed by law on the holder of an office in several ways. One, they may be prescribed by some special or private law. such as an official action of a township or committee, i.e., under an optional charter, such as the Faulkner Act, all right, or a provision of a municipal charter, as I just said, or they may be imposed by a general act of the legislator as in a state, or they may arise out of the very nature of the office itself, i.e., the office of the crown. Okay? We must understand that. And the attempt is made to identify the powers and the duties of the county prosecutors with those of the Attorney General, and then to identify the powers and duties of our Attorney General with those of the Attorney General of England. History belies this contention. The Attorney General of New Jersey could never have exercised the wide powers of the Attorney General of England in the face of Article 3 of the Constitution of 1844 and of 1947, distributing the powers of the government among three distinct branches, i.e., the legislative, the executive, and the judicial. Did y'all hear that? The governor, the Attorney General, nor the prosecutor can handle what the Attorney General of England had to deal with a fusion of government, let alone a separation of government, all right? It says that no person or person belonging to or constituting one branch shall exercise any of the powers properly belonging to either of the other, except as expressly provided in this Constitution. Okay? Even under the Constitution of 1776, the powers and duties of the Attorney General of New Jersey were quite different from those of the Attorney General of England. Now remember, the Attorney General in 1776 was who? William Patterson, William, uh, what was it? William Patterson, William Franklin, no, William Livingston, and then William Franklin. Okay, William Livingston was the first one. William Franklin was the first president. William Livingston was, William Franklin was the first world governor. William Livingston was the second world governor, and William Patterson was the third. Okay, so they never had to deal with the authority of an attorney general who actually worked for the crown. Okay, you must understand that. So even under the Constitution of 1776, the powers and duties of the Attorney General of New Jersey were quite different from those of the Attorney General of England, especially is to be noted that in England, the prosecution of a crime was traditionally a private matter. It was not until 1879 that the Office of Director of Public Prosecutors were established by Prosecutions of Offense Act established by Queen Victoria. Okay, Act 42 and 43 of Victoria. All right, as well as Edward VII. All right, these were acts passed by them in regards to the action of a prosecutor and private prosecutor versus public prosecutors. Okay, there was a difference. It stated that the English prosecutor need act only in offenses punishable by death, offenses against the coinage, fraudulent bankruptcies, and violations of elections of law, which is what we're questioning today. Okay, elections of law. Howard, Criminal Justice of England, 1931-98. Jackson's The Machinery of Justice in England, 1940. 111. Hence, however, public prosecutors superseded private prosecutors long before the Revolution. As early as 1686, we find a record of the colonial attorney general appearing for the king in West New Jersey. You hear that? Burlington Court Book, Reed and Miller edition, 1944, 56 Point in East Jersey. The king's attorney general prosecuted culprits for minor offenses to murders. Okay? The king prosecutors was the one who represented matters in the court of law. Okay? We must understand that. Let's move forward. In 1812, the Attorney General was authorized by statute to appoint deputies to prosecute the pleas of the state in such counties as he may not be able to attend in person. We find the first mention by name of prosecutor in each county. This act is the precursor of the first clause of revised statute 2:182-5 on which the defendant relies heavily. Each prosecutor of the pleas shall be vested with the same powers and subject to the same penalties within his county, as the Attorney General shall by law be vested with or subject to. I repeat, each prosecutor of the pleas to be vested with the same powers and subject to the same penalties within his county as the attorney general shall by law be vested with or subject to. This is a 1953 case from the Supreme Court of New Jersey in regards to the power and the authority that prosecutors have. And they said that they were held to the same liabilities, okay? Each prosecutor of a plea shall be vested with the same power and subject to the same penalty. You hear that, y'all? This is 1953. This is also in the revised statute. Let's read it for ourselves right here. 2023 New Jersey Revised Statute, Title 2A, Administrative Civil Criminal Justice, Section 2A 158-5, Powers, Duties, and Liabilities of a Prosecutor. Let's read it in its entirety. Each prosecutor shall be vested with the same powers and be subject to the same penalties within his counties, as the attorney general shall by law be vested with or subject to, and he shall use all reasonable and lawful diligence for the detection, arrest, indictment, and conviction of offenders against the law. You just read that in the Supreme Court case. Each prosecutor of the pleas shall be vested with the same powers and subject to the same penalties within his county, as the attorney general shall by law be vested with or subject to. Same language. It is important to observe, however, that the numerous civil duties of the Attorney General have not been assigned to the county prosecutor in each county. His duties are largely, if not exclusively, on the criminal side. It is significant to note, moreover, that exclusive grant of his power to him on the criminal side. The criminal business of the state should be prosecuted exclusively by the prosecutors of pleas, except in counties where, for the first time being, there may be no prosecutor, or where the prosecutor desires the aid of the attorney general or as otherwise provided by law. Revised Statute 2:182-4. All right. This statute has remained on the books for 55 years without challenge as to its meaning. You hear that? There are no cases in New Jersey construing it. The clause clearly represents the legislative response to the problems of law enforcement that were reflected in the rapidly increasing population of the state and the complexities of life in many urban communities, and in the need for the concentration of authority in the county for the detection, arrest, and indictments and conviction of criminals. Significantly, the county prosecutor of Bergen County is allowed a staff of 9 county detectives pursuant to that said statute 2:181-35, which they are appointed with. All right. Further. Neglect of official duty. Every public officer commits a misdemeanor who willfully neglects to perform any duty which he is bound either by common law or by statute to perform, provided that the discharge of such duty is not intended with greater danger than a man or ordinary firmness and activity may be expected to encounter. The indictment clearly sets forth breaches of an official duty by the defendants, i.e., the attorney general, prosecutor, governor, whoever else who are violating the law, and his failure to act with respect to matters concerning which he is expressly charged to do so by the statute. Though some of the statutes from which the defendant's duties spring are pleaded, they need not be. In those instances where the duties are prescribed by some special or private law, the indictment must show the source of the duties, by whether duties are imposed by a general statute or arises out of the very nature of the office. The source of the duty need not be alleged in the indictment, for the courts will Parts of. Let me read that again. In those instances where the duties are prescribed by some special or private law, wow, come on, are now prescribed by some special or private law, the indictment must show the source of the duties, but where the duties are imposed by a general statute or arise out of the nature of the office, the source of the duty need not be alleged in the indictment, for the courts will take judicial notice of such duties. All right? The court would take such notice of such duties. There is no flaws in the indictments on this grounds. Regardless of the statutory duties herein before set forth with respect to the detection, arrest, indictment, and conviction of criminals, and regardless of whether or not he had used all reasonable and lawful diligence, the defendants insist that no amount of inaction and neglect as to any or all of his duties, whether prescribed by statute or by common law, will render him liable to indictments for official misconduct, for the reason that the defendants and quasi-judicial officers immune and is claim from criminal attack unless corruption on his part is charged in the indictment and is proved at the trial. It is to be noted that in some jurisdictions, a county prosecutor is not subject to a civil suit for damages at the hands of an aggrieved citizen. Come on. Of an aggrieved citizen. Though that point has not been passed on here. Did you hear that? Though that point has not been passed on here. All right. If the defendant's position is sound, then the public and individual citizens alike are without redress in the court against county prosecutors who decline to act with respect to any phase of his statutory of his statutory or common law duties unless it is alleged and proved that he does so corruptly. If the law were, as the defendant contends, a honest but negligent prosecutor, points out, if the law were, as the defendant contends, a honest but negligent prosecutor would have it within his power to cripple or nullify the enforcement of the criminal law in his county, or to choose at his pleasure the portions of the criminal law he would enforce. He would have his county he would have in his county the suspended power sought so strenuously by the Stuart king. Did you hear that? It stated once again that if the law were as the defendant contends, i.e., the prosecutor, the attorney general, on the authority of the governor, if the law were as the defendant contends, a honest but negligent prosecutor would have it within his power to cripple or nullify the enforcement of the criminal law in his county, or to choose at his pleasure the portion of the criminal law he would enforce. He would have in his county the suspending power sought so strenuously by the Stuart king. So they wanted the power of the kings, in which United States versus Lee said that the Stuart king stripped the laws of Parliament from the crown. Okay? We must understand. Right here. The pretended power of the pretended powers of suspending of laws or the execution of laws without consent of Parliament is illegal. There is no difference in principle, and there will be no difference in effect except as to territorial range between a Stuart openly defying and preventing the execution of the law and a county prosecutor winking at a tolerate or a prosecutor winking at a tolerating partner. So let me read that again. There is no difference in principle, and there would be no difference in effect except as to territorial range between a Stuart openly defying and preventing the execution of the law and a county prosecutor winking at intolerating the violation of the law. So it says the county prosecutor winking at intolerating the violation of the law, meaning he's okay with it. Each is utterly inconsistent with the range of law that is the ideal and goal of the common law and equality before the law, which is the fundamental tenet of American polity, i.e., the law of the government. In his county, as we have seen, the prosecutor is the foremost representative of the executive branch of government in the enforcement of criminal law. He is an officer upon whom the state relies for the prosecution of all criminal offenses within his jurisdiction. If he fails or refuses to act, the law is voiceless and powerless, and it is paralyzed. From such a fate, point so. From such a fate as we have seen, the statutory scheme of law enforcement in each county seeks to protect each community and every citizen, and fortunately for the general welfare, there is no rule or principle of common law that frustrates or imperils the statutory intent. One in office is indictable at the common law, confirmed by statute and in most of our states, if he willingly or corruptly neglects or declines any official duty equally, whether prescribed by written law or by unwritten law. Did you hear that, my brothers and sisters? Whether it's prescribed by written law or by unwritten law. Misconduct in office or official misconduct means, therefore, any unlawful behavior in relation to official duties by an officer entrusted in any way with the administration of law and justice, or as otherwise defined, in any act or omission in breach of a duty of public concern by one who has accepted public office. The term is broad enough to include malfeasance, misfeasance, and nonfeasance. Under some statute, it is necessary that the misconduct should be willful and corrupt, or willful and malicious. But in the absence of such, once again, but in the absence of such provisions, corruption or criminal intention is not essential. The official doing of wrongful acts or official neglect to do an act which ought to be done is sufficient. Okay? It's sufficient. In closing, the state openly acknowledged on argument that there was not a single authority to support its position in a cause involving the one held by the respondents, and attributed the omission in the document in question to bad draftsmanship, which we are asked to repair by judicial treatment. The respondent emphasizes, I, this will be the state or the attorney general, the uniqueness of the indictment to be construed, avowing, for this first time in the history of the United States and of England, as well as a prosecutor is here charged with criminal liability for nonfeasance without allegations of corruption or bad motive. The asserted liability does not arise from statute, but is found, everybody said, in the common law. It's found within the common law. So, in closing, the basic question to be determined then is whether the prosecutor of pleas by virtue of the provision of the statute, revised statute 2:182-5, has the primary and dominant responsibility in the county, as the majority of opinions assumes, to detect and arrest any person who violates any of the criminal statutes or the common law with respect to crimes in a county in which he has jurisdiction. The section in question does two things. It invests him with the power that the Attorney General should by law be invested with or subject to, and secondly, it requires that he should use all reasonable and lawful diligence for the detection, arrest, indictment, and conviction of offenders against the law. Okay? He's obligated. The primary police duty argues for, in this case, it must be conceded, was never in the Attorney General. The Attorney General was originally the principal law enforcement officer insofar as the prosecution of pleas in the state was concerned, and it was not until 1822 that the appointment of persons to prosecute the pleas in each county was authorized by the state. This statute appeared in Nixon Digest 1846, page 52. But this statute is not the forerunner of the section here in question, as the state contends. During all the periods of time from the adoption of the Constitution of 1776 up to 1874, the peace officers of the state were the sheriff and the various constables and policemen appointed in the various municipalities. They were charged with the primary duty as police officers for the detection, arrest, and violations of the criminal law. As of today, the sheriff is still possessed of all his common law powers as a police officer, which are specifically set forth at some length in in, at some length in Blackstone's Chitty Criminal Law. See the notes in Elmer Dodge's page 452. There is nothing in the statutes abolishing these common law duties of the sheriff, so I have come to the conclusion that he still has the power as a police and peace officer in the county where necessary to arrest anyone on a criminal charge. I think that might be it. Oh no, that's not it. The state has not cited any cases. The state has not cited any cases where a prosecutor or prosecuting attorney has been indicted for non-feces under the facts and circumstances here presented. All the cases they rely on, some of which are quoted from, and the majority opinions are causes where a prosecutor or prosecuting attorney or some other officers was removed from office in removal proceedings, which is a entirely different situation from an indictment for a crime. In such proceedings, the respondent only loses his official office and the prerequisite thereof. These are of minor consequences which compared with the penalties which are imposed on a conviction for a crime. What we what we are concerned with What we are concerned with here is a criminal offense at common law, and constituents of such an offense are an evil intent and unlawful act. The situation is likewise different where the criminal offense is based upon a statute. The legislature may, if it will, make an act criminal without regard to criminal intention. Hence, it has been held that in the absence of express words in the statute making the act criminal, there must be charged in the indictment that the offense was committed with an evil intent or unlawfully. Okay? Or unlawfully. From time immemorial, a common law crime consists of two elements: a charge of criminal intent and a description of the criminal act. The authorities above referred to are the only authorities cited by the state. They are even partially persuasive to support their argument that a corrupt motive or evil intent is not of the essence of the crime of malfeasance or nonfeasance. All right, I think that's it. Yeah, that's it. So, in closing, my brothers and sisters, friends and families, so in closing, the governor, the attorney general, prosecutors, or anybody they work for are de facto, okay? They are de facto, all right? And a monarch, a regent, i.e., your governor, is the one who acting as the ruler or the governor or the head of state which is a person appointed to govern a state pro tempore, i.e., for the time being, because the actual monarch is a minor, absent, incapacitated, or unable to discharge their powers and duties, or the throne is vacant, i.e., interregnum, and a new monarch has not yet been determined. So the defendants, i.e., the state of New Jersey, are aware of my return. Okay? They are aware of my return and now have to deal with my return. Okay? So if everyone at the sound of my voice understands this lesson that was taught today, that the people you see behind me, such as your governor and your attorney general, i.e., prosecutors, are all de facto and they do not have the authority to supersede any uh, uh, authority that was there prior to their enactment. Okay, I'm saying it's very important that as your king, I'm obligated to speak on your behalf, and I'm doing that as of right now, not just in the criminal case, but as well as in the chancery case. And this matter needs to be understood in regards to the position that the state is taking over the state of Patterson, I, the municipality, not the state of Patterson, but the municipality of Patterson, which they don't have the authority to supersede because prior to the Patterson being incorporated, that territory within the state was all subject to the authority of the crown, which I represent. Okay, so with that, I love you all. Thank you all for being here. Once again, I hope that the lesson was clear. I hope that you all get a chance to go back and review this information because it's of a dire need. Okay? It's of a dire need that you understand the transition that's taking place right before your eyes. Okay? At the hands of the appellate court, the Supreme Court, and shortly after that, it will be the King Bench, which I will be head of. So with that, I love you all. Thank you for watching. I'm gonna greet at you, and I'm gonna meet at you as I always have, and that's in peace and love. All right, Bishop, make sure you throw up the thumbnail to match this lesson, as well as it's just wonderful to just be here and be able to break bread with my brothers and sisters as they did in the upper room, based upon the abstract story with Jesus Christ. With that, I'm going to say peace. You can all talk amongst yourselves now. All right. Any questions before I go out? Any questions? Anybody got any questions? Ask them now. If not, please give me a thumbs up in the chat. Any questions? Peace, Brother McGarrett from House McGarrett. Any questions? Peace, Archbishop Bound from the House of Belmont. So Brother McGarrett ain't got no questions, and Archbishop don't have any questions. Any more questions? Any questions from anybody? Council Search, you don't have any questions. And Brother McGarrett, he good. That's what I'm talking about. Brother Nunley, he's good. That's what I'm talking about. What about Allende Alade? You made a remark that said, what is lots do you know how to cast? What you mean by that? Please fill me in your question before I go get off the platform. What do you mean by that question? Anytime, Brother Thompson, Victor Thompson from the House of Thomas. Luland Temple Security Brigade. Yes, sir. There is no bar for the king. No time bar for the king. Luland Temple Security Brigade. I'm waiting for your response. Allende Alede. What do you mean by what does a lot do you know how to cast? Yeah, I know how to cast lots. I know how to play dice too. All right. Thank you, Countess Middleton. I love you all so dearly. Time is near for our ascension, brothers and sisters. Time is near. So with that, thank you all for showing up. And I'm going to see y'all when I see y'all. Peace.